Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to another episode of Building the Bridge. And I have the honor of having with me today Tiffany Comprés, an international arbitration and litigation attorney based in Miami and Paris, right?
Correct.
Thanks for being with us. Can
For
you
having
tell
me.
us why arbitration is important in international business?
Well, Steve, there are a couple of reasons. The most important one in is that arbitration awards, unlike court judgments, are enforceable internationally. So let me give you an example to explain what I'm trying to communicate. Let's say that you're in business with somebody in Belgium, right?
Mhm.
Then you have a problem with them, right? And you're saying, okay, I have to go to Belgium to sue them. That's not convenient or comfortable for me. I don't speak the language. I need to go get an attorney in this country that I don't know. I don't understand their laws. What laws are going to apply? Is that convenient for me? Is it beneficial for my case? On the other hand, you could draft in a contract that any dispute will be decided in the United States, in your state, in the district court in your state. Great. Now what happens? You have to go serve them internationally, and it could take a year. And then you've got to drag them over here. And then once you get the award, you've got to try and enforce it over there. So you have to go to court again over there anyway. And it might be a whole other re-litigation of the same issues. Also not interesting from the perspective of time, business expense. None of these things are beneficial to you. That's why you put in your agreement an international arbitration clause, because there is an international treaty called the New York Convention. There's also one nicknamed the Panama Convention for South America that requires that the signatory countries enforce international arbitration awards as if they were domestic judgments. This is a big, big deal. There is no similar international treaty for court judgments. So you want to have these clauses in your contracts because they will make enforcement so much easier, especially if you're dealing at the level where the party or company that you might be litigating against may have assets in different jurisdictions.
Okay.
Then it's much more simple to use this one award and go enforce it everywhere than having to try to domesticate a court judgment everywhere.
Let's say you're a US business doing business with a company that has locations all over the world. Do you have to check if there's a convention for each location where those subsidiaries or branches are, or
That's a really good question. And there's one convention, the New York Convention, which most nations that are involved in international trade have signed. You're talking about over 100 countries. There are very, very few outliers. And then the Panama Convention overlaps with it significantly. And those involve most of the countries in South America and the United States. Usually, you want to make sure that at least one of those jurisdictions has ratified the treaty.
right? That makes sense. Otherwise, it's like what we learned it when we were at Georgetown, right? Is this caveat emptor, right? Like buyer beware. If you're dealing with companies that are based in places that have no protections and there's no way to enforce, even if you have an arbitration, you can't enforce it. You want to be careful. That's why they need to consult with you beforehand, right? To make sure
Precisely.
This could be very problematic down the line. And I guess that's going back to my question, why is it important? Is because it's like you said, it solves so many issues before, it avoids so many potential problems from the beginning, right? So that clause is incredibly important in those contracts.
Exactly. And what I tell my clients often is that if you don't have a clause like this in your contracts, and in order to use this method of dispute resolution, you have to have it in your contract. If you don't have the clause, then you're very possibly going to get a beautiful judgment on paper that you can't actually collect on. It'll be nice, you can frame it, you can hang it behind your desk, but you may not actually be able to collect on it. And then what good is it?
Absolutely. Right? Absolutely. So that's the first piece of advice you give people, I guess, is to make sure that these clauses are in place.
Exactly. And then each clause should be tailored to the business that the companies are doing. Just to go back 1 second to your original question about the treaties and the countries,
Mhm.
to give you a sense of perspective, 168 nations have ratified the New York Convention. So you're going to be hard pressed to find a place that has not signed it.
I guess any country that wants to be taken seriously on a business level globally
Internationally.
would have ratified that treaty, right?
Exactly, exactly.
Okay, that's good to know. And would you recommend that people, when they're negotiating the contracts, talk to you, or is this something that a corporate attorney would understand, I guess to a level of depth that would be sufficient to put in that clause, or do you need to be involved in that process as well?
That's another great question. So oftentimes what I have seen is that corporate attorneys will take a clause from another contract and just stick it in there.
Mhm.
And the result is a big problem. Because, for example, one of the things that I've seen is what we call pathological clauses, which means that clauses that are technically written accurately, but are not enforceable because of some reason. For example, I've seen situations where the arbitration institution that was supposed to handle the arbitration
Mhm.
no longer exists. Then you have an unenforceable clause and you have to go to court.
Wow.
So you're back at square one. Just to give you an example. So
I was playing devil's advocate because I was a former corporate attorney and I saw that tendency of using templates and just throwing that clause in, like a force majeure or whatever other clauses you just see. You don't even know what their purpose is or if they're really tailored to that specific business deal. And they really
exactly. And I'll tell you, there are certain situations in which I tell my clients, you know what, in this deal, it might actually be to your advantage not to have an arbitration clause. Those situations are rare, but they do
Okay.
happen. And then you also want to choose an institution that is the institution that's best suited to handle the parties involved and the kind of case that might originate there. For example, there's a specific institution for disputes in the Americas
Okay.
involving the purchase, sale, distribution of fruits and vegetables. There's a specific institution that is focused only on those laws applicable to that very niche industry. So you need somebody that will know that. On the other hand, you might want to use the ICC, which is one of the biggest and one of my favorite institutions, because they might be a little bit more expensive, but they have people that review the awards in detail to ensure that they're enforceable. You might choose yet a different institution because costs are important to the client, the cost might be lower, and they really like the panel, the panel arbitrators that are, or the roster of arbitrators that institution uses. So there are a lot of things that go into crafting the right clause for a particular deal.
There's one common theme that I've seen in doing all these interviews with others that work with international clients, and that's the repetitive moment that you see with a lot of clients where, they say a penny wise and a pound foolish. And you talked about that ICC being more expensive, but you have to think long-term and protecting your assets and protecting your investment and potential dealings in the future by spending money wisely up front, right? Even if it's more than you had originally anticipated.
Precisely, absolutely. And that's one of the issues that I think we might need to talk about a little bit. Some of our listeners might not know exactly what arbitration is. So let me just go back to basics for 1 second.
Sure.
And explain some of that because it's related to your question. So arbitration is basically a private court, right? Instead of going to the court that's run by the government, you agree with your counterparty in the deal that if you have a dispute, you will go to this private court. So in that private court, you can choose your judge. We call them arbitrators. I sit as an arbitrator and I also represent parties as counsel. So I know both sides very well. So you can select an arbitrator that knows your industry, that is familiar with the laws that are applicable in this case. You really have a lot of control that you don't have in court litigation, where you draw a judge by lottery. Your judge may or may not be familiar with the the laws that are applicable or with the industry, and that could be a disadvantage to you. Of course, you have to pay for that, right? You've got to pay the judge, which is not something that is relevant to being in a courtroom. You don't pay the judge, it's part of your taxes, right? So that's one of the aspects that is important for clients to consider and to understand that there may be a higher expense on the front end, right? Or with this specific aspect, but you also save money because in the long term, we avoid the enforcement issues that we discussed earlier on. And another benefit of arbitration is that you don't have that in-depth, invasive discovery that you have in the United States. So some of our listeners may not be from the United States and may not be familiar with this concept, but in courts in the United States, you have a very, very intense, for lack of a better word, exchange of documentation relevant to the case. And relevance is very broad. It can encompass almost anything. Emails that you never thought would see the light of day are suddenly in the spotlight in court.
Yeah,
That's very frightening for a lot of non-US companies.
What I would call exhaustive to the point of absurdity. And that translates to being very expensive because that's all
hugely expensive.
Of course.
Hugely expensive. It's one of the biggest costs in US domestic litigation or in any litigation that takes place in the US. In arbitration, the biggest cost is in certain cases where you have 3 arbitrators, so you have 3 judges, and that's a big cost source in arbitration. However, if you have just 1 arbitrator, which you can stipulate in your arbitration agreement, then you're in a better position from that financial perspective anyway.
Of course. Wow, this is just so complex, Tiffany. How do potential clients that are wise enough to understand the value of arbitration and having the right clauses in their contracts before they jump into big business deals, how do they get in touch with you?
They can email me. It's tiffany.comprés@fisherbroyles.com. That's my firm. And I'm always on email. I'm very attentive, so you can always reach me there.
Fantastic. Thank you for sharing your time and your knowledge with us today.
My pleasure.